All right, Randy Manning here for another verdict breakdown with a regular contributor, Jessica McBryant. And today we are talking about Hannasch versus the bad guys. And we're going to have Jessica break down the case. What was the plaintiff like? What was going on? How'd you guys end up in a courtroom?
Sure. So this was one of the weirdest stories for how a crash happened that I have ever seen. Our client was on the highway and went off to an off-ramp, and there was a stop sign at the end of the off-ramp. And she was rear-ended by a defendant who bounced back and forth between the concrete medians and then rear-ended her. Despite doing that, they did not admit liability, and they did not admit responsibility, never offered more than like $40,000 until mediation. And our client had a shoulder injury and a back injury, and she was recommended for a surgery on her, or she had a surgery on her shoulder, and then was recommended for a fusion on her spine, and had not gotten it by the time of trial. And their argument was that she wasn't going to get it, that she just needed to have a little more PT, so they weren't willing to consider it. And based on that, because their offers were below her past and future medical expenses, she had no other choice but to take the case to trial.
So let me get this straight. I mean, we've all heard defendants lie, but this lady's playing like what, bumper cars with the median, bouncing back and forth, and then continues and runs straight in, and she goes into a courtroom and says, this wasn't my fault. It was the person who was stopped at a stop sign?
Yeah, they said it was a construction zone, so the way this median was set up had changed recently, and she said there was no stop sign, and that our client stopped unexpectedly and suddenly. So the defense to a rear-end collision is a sudden and unwarranted stop from the vehicle in the front, so that's what they claimed as their defense. And she also claimed she was going the speed limit, which was 35 in that construction zone. But in order to continually slide off the medians and still hit her, not see her, not be able to stop, she had to have been flying.
So I'm just like salivating over this crash, right? Like, it means you guys just light this lady up, or walk us through the cross-examination of the defendant.
We were very excited for it based on these facts and how ridiculous it was to us that she wasn't saying it was her responsibility, that it was her fault. And just the photos of the vehicle have scrapes up and down both sides of her car. And so we were ready to just hammer her and destroy her. And she was a 19-year-old girl, sweet as can be. And we were worried that if we did that, if we were aggressive with her, if we tried to show how ridiculous it was, that we would look like bullies. So we switched strategy, and Jared Mazzy is the one who did her cross. He was very kind, very patient with her, and kind of acted like a disappointed parent might. Like, are you sure that this might not have been your responsibility? Are you sure you were going 35 miles an hour? It doesn't seem right. And so I think that strategy helped. And even when talking to the jury afterwards, they said that they appreciated how kind and respectful that he was of her.
All right. And so there's this other weird issue in this case, this Family Car Doctrine. And, you know, I was a licensed attorney for probably 10 years before I figured out what this was. And, you know, I'm joking, but I had to insure my son, who is going to get on my auto policy. I'm like, let's get this kid, you know, just enough to not be in violation of the law. And I heard about the Family Car Doctrine, which would mean that I could be responsible, since he lives in my household and I own the vehicle, for whatever he did. You had that in this case.
I did. Because the defendant was so young, and the policy limits in this case were $500,000. And I was worried if I just bring this 19-year-old girl into trial by herself, because we aren't allowed to talk about insurance and limits in trial, jury's not allowed to hear about it, I was worried that they would look at her and say, how is she possibly going to afford what we were asking for? And so I brought her father into the case, into the lawsuit under this doctrine, which only applies parents to children. And they ended up admitting all of the factors, and so we didn't have to prove anything about it. And all we did was say the law says that we could bring this claim against him. They've admitted it, and so he is here with her for reasons that you don't necessarily need to know, and tried to hint that insurance were those reasons as often as we could without violating the rules, and I think it helped.
And that's interesting. I mean, so you did explain it to the jury. I mean, I feel like if you just had like an older male sitting in the courtroom, somebody would raise their hand and be like, who's this guy? But how did you get that across to the jury? I mean, did you just say, hey, she brought her dad for supervision? What did you say? You just said it was legal reasons. And did you say it in opening or voir dire, or when did you start that?
I believe it was opening when we first did it. And
Okay.
He was also a surgeon. So we called him Dr., I think it was Hurlbut was his last name. So we called him Dr. Hurlbut when we introduced him, and tried to get that in their minds as well.
So interesting to me. I mean, was he animated at all? Like, oh, I can't believe I'm here. Or was he like really stoic? I mean, what was he doing?
He acted angry the entire time.
Okay.
He acted very angry. When we would talk about how his daughter was responsible, he would get angry. He'd be telling the opposing counsel that they needed to do this, that they needed to make this different strategy. Eventually you could see opposing counsel getting a little frustrated, but he did not act like he was okay with being there.
So I did come and check out a day of trial, and I can't remember when I got there, but the defendant's attorney was prepping the defendant in the courtroom. So I'm sitting there in the courtroom, and everybody's gone other than us. And he's sitting there with her on the witness stand saying all of these things about what she was going to say in court, and even kind of like poking holes in her outrageous liability defense. Had you ever seen anything like that?
No, and I never thought I would. It looked like he was very unprepared, hadn't met with them, hadn't talked to them before trial, and so he was doing it there, and he didn't care that we were watching, which was incredibly odd. And then to give us some pointers in things he even didn't believe was strange.
I thought it was a trick. I was watching this and I was like, oh man, this is a real trick. Like, I'm gonna go pretend like, I'm gonna, prep this witness for this, and this, and then she's gonna say something flipped on the stand. How did you guys process that and deal with her cross, pretty much having a preview of it?
I don't think we really changed much at all.
Yeah.
It did give us a view into how we should treat her, because she was getting frustrated with him being a little more aggressive. So that helped confirm, we should just act kind, and whatever she says, crazy things that she's going to say, it is what it is. And, if she came up there and said, I was responsible, sorry, then you just deal with that when it comes.
Yeah.
She didn't.
Another interesting thing in this case is, so, for those who don't know, the defendant gets to go and pick a doctor. They get to go pay a doctor. And this doctor performs an evaluation as an expert witness. And sometimes you get good opinions from the defendant's doctor. In this case, that happened, and you actually ended up calling the defense's doctor in your IME, or in your case in chief. What was that like, and how did you keep him under control?
Sure. I would say it's rare to get a defense doctor to give good opinions in these cases. A lot of them are frequent flyers with insurance companies, so they're worried if they don't tell the insurance companies what they want to hear, then they won't get hired again. So this doctor, Dr. De La Rosa, was a shoulder orthopedist, and his opinions said that this car accident caused her injuries, and not only that she would need a future shoulder replacement as a result of the collision, which is something even her doctor hadn't said yet. So we cross-endorsed him in a supplemental 26A2 disclosure, let them know we were going to call him. This is what we anticipate him testifying to. And then we asked if we could contact his office for scheduling. They said yes. And then he ended up, we gave my cell phone number. He called me. So I didn't meet with him before, which was a little nerve-wracking since there's some rules about talking to the other party's experts. But he ended up, I just asked him, what's your opinion here in your report? And kept it simple and short, and it worked out.
That's amazing. I think my head would have exploded in this trial because we have, well, we're going to call the defense doctor because he's one of our best witnesses. We get a preview of the defense's, the defendant's testimony. I think I would have overthought all of this and my head would have exploded or something. I think you guys handled it really amazing. And then there's this other little legal thing that there was a little trick that the defendant attorneys did. And so they had a defense, which they have to disclose, and that's, hey, we're not responsible for the damages because of this fact. And this, in this case, is this weird one, failure to mitigate. You didn't do enough to help yourself after I injured you. They drop this and then argue it in closing. So walk us through that.
Sure. A failure to mitigate defense has to be pled affirmatively. And then throughout discovery, we ask them, what is the basis for this defense? And just like our claims that we bring, we have to have evidence to support it. And they couldn't give us any. And so we go into trial after filing a trial brief on how they shouldn't be able to bring this defense because they can't prove it, and then argue it with the court. And the argument was they've produced zero evidence, they can't produce a viable theory, so they shouldn't be able to bring it. And the only thing he could argue was that she should have had more physical therapy, therefore she doesn't need a future surgery. But there is a counter argument or a defense to the defense of failure to mitigate that you aren't forced to undergo a serious invasive surgery to mitigate your damages. Mitigation is undergoing something more expensive that you didn't need, that you shouldn't have done. So their theory didn't make any sense. The judge agreed and told them they couldn't bring it. And then opening statements begin. And one of the first things he says is she should have gotten physical therapy. Because she didn't, she shouldn't be able to get money for her surgery. And I objected and said, they're now arguing the defense that they said they weren't going to bring. They agreed with the court. So I lodged the objection, made sure the record was clear on appeal if we wanted to appeal that issue about arguing a defense that they're not allowed to argue.
And what did you win the argument with the court? I mean, what did the court do?
Just said the objection is noted, and then said that opposing counsel needed to be careful. They brought it up a couple more times throughout trial, still objected, and didn't seem like opposing counsel really cared.
Oh, so the judge let them argue this, even though the claim was dropped.
A little bit. He gave them an admonishment, told them to be careful, but.
That's interesting. I mean, I think that it helps. I mean, if they're taking that big of a step, even if the judge is gonna, potentially make a bad ruling or hose you. I mean, that's, if they're gonna hose you, it at least helps get it in the defendant's attorney's mind, like, yeah, you're getting away with this, but this isn't the path you want to go down, and now the record's preserved on appeal. Do you agree with that?
Yeah, I agree with that.
Yeah. Well, it's just a wild trial. So let's get into some of the mechanics. I mean, you had offer. What was the offer before this trial?
The offer right before trial was about $300,000.
Okay. And then what was the verdict? What was the final outcome? And I'll show you our book of verdicts. It's almost...
Yeah, so the final verdict was $350,000. So they awarded $150,000 for economic losses. She had about $100,000 in past medical expenses. And then talking to the jury after, they gave her $50,000 in order for her to get the future fusion that we were talking about. And they said they gave $50,000 because they considered health insurance. and that they thought that she wouldn't actually have to pay the $250 that we used Acumed to bring. And so unfortunately, we can't tell them not to consider insurance, so they did. And then they awarded $100,000 for non-economics and $100,000 for physical impairment, which we're pretty happy about considering that it was Douglas County.
Oh yeah, that's a fantastic verdict. So they offered you 300, you win 50,000 more, and that's it, right? Or do you get any other prizes and goodies for winning a trial, or did this client?
Sure. So one of the reasons that we decided not to accept the $300,000 based on $100,000 in past medical expenses is that you can be a little more confident about a jury awarding those. They typically will. And then you know that if you take it to trial, that you're going to get interest and costs on top of the verdict. So if we went to trial and all we got was her past medical expenses of $100,000, with interest and costs, we're over their $300,000 offer. So the verdict of $350,000 turned into $550,000.
Oh wow! And so the verdict comes back. Is the client thrilled and ecstatic? And how did she react?
She was a little disappointed, and honestly, we were too. We hope that a jury will award what we ask for, especially for economic damages, and the fact that they considered health insurance when they're not allowed to consider health insurance, and that we have to enter courtrooms and not talk about it, and we can't even say, we can't talk about it because you're not allowed to consider it, and have to play these games about, even car insurance is going to pay. Can be very frustrating, but ultimately it was still more than they offered, and she ended up being happy with the outcome and what we were able to do for her, and she felt like she was able to tell her story and that this trial was cathartic for her, especially having dealt with years of this defendant who she went to church with, telling her, I'm not at fault.
Oh, so I didn't realize that. So she's going to church every day and is like, hey, do you want to take responsibility for the car crash? And are they talking about it at church? Or
they didn't talk, but after the collision, they were very standoffish, and the dad was angry about her having to take responsibility. And so for some reason, the family got behind her and didn't want her to be responsible for her actions. And it was definitely frustrating, and she finally felt like she got some justice.
Well, that's a wild story, and in my experience, telling the clients about all the cost and all the the interest that you get, it doesn't always sink in. You know what I mean? It's like running out the door and getting, hey, honey, will you grab some milk? Like, that's pretty easy for me to forget, at least. And I think that's kind of how the clients are. It's like, oh, I only won $350, and then you send them your motion for entry of judgment with the cost and all the extra prizes that you win for getting trial verdicts, and then they're like, whoa, this is a lot more than I was thinking about. You know what I mean? Was there a moment like that for her down the road?
I don't even think it took that long. It just took to get out of the shock of trial. And I say shock because I feel like it can be like that for a lot of clients. And even when you're talking to them before trial about you can take this offer or we think you can get more, it's a lot for them to actually go through it. And I feel for them, and I would never want to be in their seat as much as I love doing trials, to be the plaintiff in a trial, to have my life and my pain exposed to a group of strangers, to have opposing counsel point the finger at me that I should have done this, I shouldn't have done that, for a week, in and out. It's exhausting, it's emotional, and so I think she just needed a breath after it was done. And another client that I'm still in contact with today, very grateful for everything that we did for her.
Wow. Well, that's amazing. I mean, another great verdict, another big win. And who was your co-counsel on that case? I think we forgot about poor Jared.
No, Jared
Oh,
Mezzi. I mentioned
he
him
did
for
the
the
cross.
Yeah,
There we go. Well, yeah, Jared, Jessica, they're a killer team, multiple verdicts. There's even more to come, so keep watching. But if you heard anything about here or in this video that, you know, made you think, you want some insight into, you want to learn more about, feel free to reach out to me or Jessica. Thanks for listening, and I hope you have a good day.